I'm very confident that the September 23rd date is not a compliance date that anyone realistically needs to worry about.
This is 401k Specialist Editor-in-Chief Brian Anderson, and this is the 401k Specialist Podcast. It's a busy time of year if you're an ERISA attorney, with the Department of Labor's Fiduciary Rule currently in purgatory and the retirement industry preparing later this week to celebrate 50 years of the landmark law that sets standards for voluntarily established workplace retirement and health plans. Today, we're happy to be talking about these issues with Minneapolis-based ERISA attorney Allie Itami, a partner in Lathrop GPM's Business Transactions Group, specializing in employee benefits and known for providing comprehensive counsel on fiduciary compliance under ERISA and the Internal Revenue Code. Welcome to the 401k Specialist Podcast, Allie.
Thank you for having me, Brian.
All right. First off, tell us a little bit about your role as a partner in Lathrop GPM's Business Transactions Practice Group. What types of clients do you typically work with, and what does that entail?
Thank you. So I work with a really great group of people here at Lathrop on a very wide range of benefit topics. Some of the business transaction attorneys are very focused on mergers and acquisitions, while others are focused much more on startups or entrepreneurs. So my work with those partners ranges from starting up the benefit plans to defending governmental audits or just day-to-day governance compliance, and ranges all the way to spinning off, merging, terminating plans, all as parts of corporate transactions. In addition to that, I also focus on IRAs, so particularly how prohibited transaction exemptions can apply to self-directed IRAs. And that work I tend to do alongside our private wealth trust and estates group. So overall, I have a really strong interest in all things fiduciary, as you mentioned, and that includes the ever-changing definition of investment advice.
That's for sure. All right. Before we get to talking about ERISA and its 50th anniversary, I want to start by checking in on the status of the Department of Labor's beleaguered fiduciary rule, which was supposed to take effect later this month until not just one, but two federal judges in Texas district courts put stays on the rule's implementation. Can you briefly take us through the process that's playing out in the courts right now, and what are your thoughts on the possibility of an appeal by the DOL in one or both of the different lawsuits in Texas?
Sure. I'll preface this by saying I am not a litigator, and I am not involved in this particular litigation, nor have I ever worked for the government. So all of my thoughts are, very speculative. But at the moment, as you mentioned, there are the two stays from the district courts in Texas, and the DOL/DOJ, because they work in tandem here, still have time to file an appeal directly related to those stays. They recently asked for additional time to file a joint report, and that request was not opposed by the plaintiffs, and it was allowed by the court. That extension brings the time to file the report close to or exactly at the time to file an appeal, which is really close to the would-be effective date of September 23rd. So if any appeal of the stay is lodged, it's incredibly unlikely that it could be decided by the 23rd. Plus, service providers have really been functioning under the impression that the rule will not go live on that date. All of which is to say, I'm very confident that the September 23rd date is not a compliance date that anyone realistically needs to worry about.
All right. And just along those lines, what are some of the compliance considerations in light of the stay rulings for plan sponsors? Are we just we're in a full wait and see mode right now?
So in discussing this with other litigators, I'm not seeing much of an upside in appealing the stay in and of itself. One of the court decisions actually indicated it would be a waste of resources to do that. So that court clearly wants to focus on getting to a decision on the merits. And given the need that the DOL would probably have to give transition relief for service providers who have sort of lost out on that compliance lead time during the stay. Trying to overturn that particular stay and get back to a September 23rd effective date, it doesn't seem like a good use of resources to me. That said, nobody has asked me whether or not this could be used of resources, but that's how I would look at it. Just, not being worthwhile and better to move on to a decision on the merits.
Okay. Do you think there's much of a chance that the Supreme Court would take up an Administrative Procedure Act case so soon after the Loper-Bright decision, or does the Fifth Circuit kind of get the last word here?
Without some sort of circuit split, I wouldn't expect the Supreme Court to take up an APA, an Administrative Procedure Act case, if the Fifth Circuit does make a decision that provides very little deference to the Department of Labor. And I expect that the Fifth Circuit will come to a decision that would not give very much deference to the Department of Labor if a decision actually gets up to the Fifth Circuit. So I would suspect that if there's not a circuit split, there would not be any particular reason for the Supreme Court to want to take up an APA case. As long as, the Loper-Bright decision is being implemented in the manner in which the majority intended, and the Fifth Circuit seems likely, based on past practices, to do that. So overall, I think the Fifth Circuit probably gets the last word here, assuming that there is a decision on the merits, and then that decision on the merits gets appealed to the Fifth Circuit.
Okay. All right. Now I'd like to switch gears and talk a little bit about the Employee Retirement Income Security Act, of course, better known as ERISA. As the industry prepares to celebrate that law with a big black tie gala event in Washington, D.C. on September 12th, as an attorney focused on ERISA and compliance under ERISA, what do you think about its legacy and its potential future?
I think that's a great question. Thank you for asking it. 50 years is more years than most U.S. employees work in their lifetime, according to an article I just read. So it's pretty impressive that ERISA has been around for that long. When you compare it to some other federal bodies of law, it does seem a little bit short. When we're talking about, securities laws, we think about acts called the 33, the 34, and the 40 acts. So obviously those have been around for a lot longer. But 50 years is enough time to really develop a lot of authority, regulatory authority, and case law. And it's also been around long enough to really be applied to quite a range of work relationships. I think that ERISA started out being highly employer dependent, with benefits slowly shifting to more individualized or even single pay or governmental in orientation sort of benefits. I think we see this with the shift from traditional pensions funded solely by employers with all the longevity risk sticking on the corporation to, the sort of medium ground of 401ks with employee and employer contributions, and then all the way to the other extreme of IRAs or state-run IRAs. And I think there's really been a similar trend also with welfare benefits, starting with medical and life insurance, and then growing to include the defined contribution accounts like FSAs and HSAs, and offering really unique options like fertility benefits. I think there's been enough time for benefits to really change and really adapt to sort of new working environments, and I do think that is something that is likely to continue growing and innovating. And probably something we're going to see ERISA stick around for too.
All right. I also saw that you recently posted a blog piece about 50 years of ERISA on the Lathrop GPM website, which we're going to have a link to on the homepage for this podcast for anyone who wants to check that out. You were also recently quoted in a Bloomberg Law article about how more use of annuities in 401k plans presents some challenges in regard to the limits of ERISA. What are the key issues you're seeing here?
Yeah, so there are definitely a couple of items that present challenges for fiduciaries in implementing and sort of in-plan annuity offering. Some of these have been partially or fully addressed by the Secure and Secure 2.0, but a number of these items sort of are still live. And I think it's just going to take time to sort of work through and see how they sort themselves out. So RMDs have been addressed by allowing for the calculations to incorporate QLACs. So that's been a good thing, but not all of the QDIA, so that's the qualified default investment account options, sort of hiccups have really been totally worked through, and that can cause some plan fiduciaries, a little bit of angst about offering annuities in their plans. I do think that there's still some stigma attached to annuities. A lot of plan fiduciaries now probably had an uncle or a father who purchased an annuity and had it turn out unfavorably. They're sort of a specter of high fees, commissions, lockups, things that still need to be overcome before fiduciaries feel very comfortable putting these on the 401k lineups. I do think that one of the sort of partially addressed categories that I mentioned earlier includes the safe harbor protection under Secure. It's better than nothing. It's nice to have some safe harbor protection, but a lot of plan sponsors kind of wish in some ways it was perhaps narrower so that there could be, more guidelines. It might be more useful to them if they had more specifics. And, being cutting edge is not really where an ERISA fiduciary wants to be. The entire body of law looks at where you stand vis-a-vis your peers. So there's not a whole lot of upside to being cutting edge. And in particular with these annuities, the upside, so the better funded retirements for former employees, probably aren't realized until long after that 401k plan fiduciary has moved to a different position. And so it just, there are a couple of items that really, somebody needs to be the first one, somebody needs to be the second one, and then I think it'll snowball once all of those peers start jumping on the bandwagon.
Interesting. All right. Interesting perspective there. Any final thoughts on ERISA issues or any other interesting issues that have your attention right now before we wrap this up?
Just like to thank you for having me. It was really enjoyable to speak with you. And in general, I'm just very interested in what the next innovations are going to be that impact ERISA. I'm excited to be part of the legal team that helps sponsors and providers implement whatever those innovations are.
All right. ERISA attorney Allie Itami of Lathrop GPM, thanks for joining us today and sharing your insights on the 401k Specialist podcast.